Toyota spends $1 billion to build robots. Who wants a Hearthstone movie? And we talked to the lawyer fighting a landmark case against a monkey. Tech News Tonight is next.
This is Twit.
This is Tech News Tonight, episode 462 for Friday, November 6th, 2015. This episode is brought to you by Epson's new EcoTank printers. With Epson's line of SuperTank all-in-one printers, you can print thousands of documents without running out of ink. EcoTank is loaded and ready to print when you are. Visit epson.com/EcoTank to find out more. Welcome, I'm Megan Morrone. Let's get to the tech news. Carmaker Toyota is investing $1 billion in a research center in Silicon Valley, but self-driving cars are only the beginning. The automaker is hiring Gil Pratt, former program manager at DARPA, to lead the new Artificial Intelligence and Robotics Research and Development Center. The New York Times reports that the Toyota Research Institute is a 5-year, $1 billion R&D effort headquartered in Silicon Valley, adjacent to Stanford University, with another soon-to-be-built lab in Cambridge, Massachusetts. John Markoff, who's been covering AI in Silicon Valley for several decades, says today's announcement signals a changing of the guard in basic technology research, with focus moving to products rather than the tradition of basic science. Wired.com says the same group of hackers who breached the personal email account of CIA Director John Brennan have now broken into a law enforcement database that includes arrest records and other sensitive data and a real-time chat tool for law enforcement agents. The hackers contacted Wired and gave them a screenshot of one of the systems they'd gained access to, but they did not reveal the vulnerability that gave them the access. The database includes arrest records directly after they've been entered into the system, which of course could be valuable information for websites devoted to breaking stories about celebrities and political figures. Wired has not confirmed that the hack is legitimate. Apple TV is the future of television. It's just about as a la carte as you can get. Choose what you want to watch, when you want to watch it, and say goodbye to ads. Well, not exactly that last part. The Next Web reports that a company called AppLovin will release an SDK later this month aimed at putting video ads on your new Apple TV apps. AppLovin says the SDK for tvOS will be in the hands of developers later this month. The intrepid undercover reporters over at the laptop section of Tom's Guide say that phone tech support reps from Dell and HP are throwing some shade on Windows 10. Tom's Guide's annual tech support showdown is designed to test how good laptop manufacturers are at providing tech support. They learned that Apple, Microsoft, and Samsung were the best at providing support, but they also found that many reps were discouraging people from downloading Windows 10. One Dell agent even recommended reverting back to Windows 8.1 as a solution to a problem that was totally unrelated to Windows 10. Now, if you've ever called tech support wrong or just plain wacky advice, should not come as a surprise to you. However, the news that Dell and HP reps were actively telling people to uninstall Windows 10 will likely come as an unwelcome surprise to Microsoft. Thanks to Dr. Mom for posting this story on the Tech News Today subreddit. If you've got a story that you want to hear on the show, go to reddit.com/r/technewstoday. Post it there or vote up the stories that have already been posted that you want to hear. We are listening to you. Coming up, what happens when a monkey and animal rights organizations and a primatologist walk into a federal court to sue? But first, this episode is brought to you by Epson. Epson's revolutionary EcoTank line of printers for home and office introduce a new age in printing. The new EcoTank ET4550 wireless all-in-one printer features a refillable ink tank. Comes with enough ink to print up to 8,500 pages, equivalent to about 50 ink cartridge sets. You're loaded and ready to print for up to 2 years. Powered by Epson's leading-edge precision core technology, it delivers high-speed, vivid colors and laser-quality black text, plus auto two-sided printing, a 30-page auto document feeder, and easy wireless printing from tablets and smartphones. Visit epson.com/ecotank today to transform the way your home, office, or work group prints. For the best combination of ease and value, turn to the new Epson EcoTank printers. That's epson.com/ecotank. And we thank Epson for their support of this show. Yesterday, President Obama released the full text of the previously secret Trans-Pacific Partnership International Trade Agreement. The document, which proposes major changes to copyright law, is over 2,000 pages long and super boring, if I may say so myself. But is all copyright law boring? No, it is not. Take, for example, the case of who owns the right to one monkey's selfie. You might have heard about photographer David Slater, who back in 2011 set up his camera to photograph crested macaques in Indonesia. One thing led to another. The monkeys took some hilarious photographs of themselves, some of the finest selfies of all time, I might say. Those photos were part of a copyright dispute several years ago. Wikimedia said Slater didn't own the photos because he technically didn't take them. They said that if there's no author of a creative work, then there's no copyright. Now the monkey selfie is back in the news since PETA, the People for Ethical Treatment of Animals, is suing Slater on behalf of Naruto, the crested macaque, who they say owns the photo. Joining us to talk about this case is the lawyer representing photographer David Slater. Welcome, Andrew Dewey, attorney at law.
Thank you, Megan.
Thanks for coming on. So before we get into the details of the case, tell me a little bit about your background and how it brought you to defend people against monkeys.
Well, my background is patent law and mostly at the U.S. Court of Appeals for the Federal Circuit and a few cases at the U.S. Supreme Court. But I've decided to make a career change, and now everything's going to be about monkey copyright law. This is my big chance.
I love it. So on his website, Slater outlines how the photos were taken. He set up the camera. The monkeys got curious. They grabbed it. They took the photos. I guess they were staring at their reflection. So I think what we're looking at now is not the monkey selfies, but Slater's actual photographs that he took that aren't in contention. But they were staring at the reflection, and what came out was just hilarious. Can you tell us any more about the specifics of how the photographs were taken?
So I'm kind of a geeky lawyer. I only care about like legal precedent and stuff that with like undisputed facts. And so David was very eager to tell me about the details of this. But what I said to him is that won't make any difference in this case. A monkey cannot sue for copyright infringement. So all of that stuff that we see in the PETA complaint and what we might say in response to that, as far as how the picture came about, is of no consequence. It's very clear legally that a non-human animal cannot sue in federal court unless Congress specifically says that's possible. And in the Ninth Circuit here, the federal circuit that we are in California, it's not possible. And so I cut that off at the pass. I said, David, I know you care about this. And he said, well, okay, well, at least tell people that the story of how this came to be is on my website. And Megan, I gave your producer the link to that website. So that's
how it came to be. So the first case against Wikimedia, you didn't care about it, but I mean, did he lose that case? I mean, did they say that there was no owner of the?
Actually, I don't even know if there was a case. Again, that's one of those things I cut off at the pass because I'm only here for the PETA case, and I don't think we're going to be doing that too much longer. But I'm just here for that, and it's I know that there's some dispute with Wikimedia, but I'm not involved in that.
So, as an expert on monkey law, why can't a monkey?
Thank you for that.
Why can't a monkey sue? Why not?
Actually, if there's, I'm joking, obviously, but as I said in my motion to dismiss today, I think a monkey should be able to sue if there's some act of Congress that's about protecting monkeys, and that monkey should be able to sue through ad litem representatives, but not in copyright law, because it's just, how could that possibly work? I mean, really, it's just not going to work. Anybody could step in. It's tough enough in like class action lawsuits where lawyers who've never met their clients try to represent them. But, just imagine this in the context of non-human animals. It's just not going to happen. And if PETA wants to make that case, as I say in my motion, take that case to Congress. Don't pretend like the courts are going to resolve that.
So there was a precedence in this case, a sort of similar case where PETA tried to sue. I think it was on behalf of a dolphin for slavery.
An orca in San Diego, the SeaWorld, right? If I remember right. Actually, I didn't quote that or cite that case in my brief, but it was. They argued a 13th Amendment, and if we all go back to our high school civics, we might remember that. That's anti-slavery. That's Civil War stuff. So it was an interesting argument, but the federal court in San Diego said, well, no, we can't say that orca at SeaWorld is being enslaved in violation of the 13th Amendment. And actually, that San Diego federal court cited the case I keep talking about, Cetacean Community, the 2004 Ninth Circuit case, saying that, unless Congress specifically says that non-human animals have standing to sue in federal court, we federal courts will not read any statute or constitutional provision to the contrary.
So they can't be enslaved and they can't take selfies. That's
yeah. I'm guessing that SeaWorld was not happy about that case because that was pretty bad PR. But and contrast the situation of SeaWorld with my client, who's a nature photographer. Matt, who spends time in the Indonesian jungle, weeks just trying to get nice photos of animals? It's somebody who cares about animals. And so it's really a cruel irony that PETA chose my client to be the target of this lawsuit.
Yeah, if you read his story, he took these pictures. He wasn't really even trying to promote them. They were just there he is there, like obviously a man of the monkeys, not enslaving anyone, not trying to take anyone's intellectual property or any monkey's intellectual property. So PETA, why are they suing?
Of course, I would suggest you ask them that. Some people have suggested a publicity stunt. I don't know. I think they're probably people of goodwill. And then the irony, again, the cruel irony is that they sued somebody who probably agrees with almost everything they have to say about protection of animals. So I don't really understand it. Certainly my client doesn't understand it. And I think that there are better places where better areas of law where PETA could spend its time, as I said, especially areas of law that are designed to protect animals, like the Endangered Species Act, like the Marine Mammals Protection Act. There's actually a big problem. And in the brief I just filed, I cited to a law review article about that very problem, is that it might be there's no human able to sue for protection of those animals. So that's a real issue. But this is not a real issue with copyright. It's the kind of thing that makes lawyers and lawsuits and the courts kind of look like a joke. And I don't like that. Obviously I'm joking, but that's just laughing to keep from crying.
So is there, the photo was taken in 2011. Is there like a statute of limitations or anything here that you...
That's kind of like the details of the photo. It's like, we'll just never get to that point. Mm-hmm. I'm guessing a lot of your viewers care about statute of limitations and copyright. And there was a very important Supreme Court case earlier this year called Petrella v. MGM it's basically a 3-year statute. And there was a debate before that case about when the 3 years start running. And what Petrella v. MGM settled was that the 3 years start running from the infringing acts, not from the creation of the work. So I direct your viewers to Petrella v. MGM if they're concerned about that issue.
So there's also some dispute that PETA even knows which macaque they're suing. Can you talk at all about that?
It's one of those details that, I'm a geeky appellate lawyer. I don't show up before juries. I just deal with the law and undisputed facts, and it doesn't really matter which monkey it is. And and that's one of those things David talked to me about. But it was like a call to the UK. He lives in Wales, and it's like, David, I think we're going to pay for this call here. This is across the ocean, and I just which monkey it is doesn't matter. So let's not spend a lot of time on it.
So you filed a motion to dismiss, and you're pretty confident that the case will be dismissed?
I would never speak for how Judge Horrick will act, but I just cannot imagine how there could be any basis. We'll see what my opposing counsel has to say. It's a major law firm, which was surprising to me when I saw it. Irell and Manila, these are top-notch intellectual property lawyers, and I don't claim to be any better than my opposing counsel in that regard, but I'm surprised that they're involved in this case, and I look forward to seeing their opposition to this.
Well, Andrew Dewey, thank you so much for joining us. Andrew Dewey is an attorney at law at Berkeley. Thank you for joining us and explaining this, and thank you for being humorous about something that I know you feel strongly about the law, and I appreciate you coming on to talk to us.
Thank you, Megan.
Take care.
Bye-bye.
And finally tonight, Activision Blizzard, the folks behind Call of Duty, plan to launch a TV and film studio. This comes after yesterday's news that Activision Blizzard bought King Digital Entertainment. Those are the folks behind Candy Crush. Is there a full-length Candy Crush of Duty film in our future? Hard to tell. The Wall Street Journal reports that a former senior strategist from Disney will take the helm of the studio, along with a not-yet-named creative executive. As the Journal points out, Activision's intellectual property dates back to the 1980s classics like Kaboom. The first production will be an animated TV series called Skylanders Academy, based on the popular game franchise Skylanders. And that's it for this edition of Tech News Tonight. You can find us on your favorite podcast app, or you can now choose between 3 different apps on your Apple TV to watch us on your television. You can also subscribe to the show at twit.tv/TN2, write to us at TN2@twit.tv, and watch live every weekday at 4 p.m. Pacific. And don't miss our morning news program, Tech News Today, every weekday at 10 a.m. Pacific, 1 p.m. Eastern. I'm Megan Morrone. Thanks for watching.
Bandwidth for Tech News Tonight is brought to you by CashFly.com.